subject to the court's convenience, we are ready to proceed.
Yes, Mr. Johnson.
If I may apologize, if I may apologize, being represented by counsel, Mr. Oladipo Ajayi. And hello, my lord. I do not know
yes,
if I can be heard.
I can hear you.
Before today, I've always been represented by counsel, Mr. Oladipo Ajayi.
Yes.
And I do not know the state of proceeding at this time.
Huh?
I do not actually know what it is supposed to be. I just got the notification this morning that the matter is going on. There is no other person to attend proceeding because of notice.
There's no other person to
attend, because of lateness of notice. So I decided to apologize on behalf of the defendants and at least seek to understand what is going on and provide appropriate action.
There are two counsel representing the two defendants. There is Benedicta
Onyodi, she is also
and there is Oladipo Ajayi, who is representing the second defendant.
Yes, both of today's proceedings. This a notice was sent to my office WhatsApp address to text message this morning around 9.
Yeah. So what do you want now?
I will try, if my lord will give me some time, let me try and understand what the matter is about, and what the applications are about. If they are something that I do not object, may proceed.
Okay, that we should stand the matter down for a while.
Probably if the applications can be recited, as in what are the applications about?
The application is for amendment, and this thing has filed, or the counter filed by. Yes. The application is for amendment, and the counsel for the first defendant file in a counter to the motion for amendment.
May I know the date of the application is supposed to be moved, because I know that there are 2 applications in the past.
The date the application was filed?
Yes, the applications to be moved today, because there are 2 applications in the same thing.
Is it the application for amendment?
Yes. If I recall correctly, before today, there was a directive by my lord to the claimant to consolidate all his applications for amendment in one application.
Okay.
If the report I received is correct, there was a directive to the claimant to consolidate all his applications for amendment in one document.
Okay.
Yes. And there was one seeking to join additional or to sue some facility auditor, and another one amend the claim. I don't know if those 2 applications have been consolidated as in joint one process. If that is the case, I haven't received a particular one.
I don't think they have been consolidated, because on the 30th of June, Rochana was here, and Benedicta was also was in court. The matter is supposed to be for hearing of our applications, but I don't know whether it was served. That was the assessment of Mr. Uchenna. Then Uchenna said, in circumstance, we asked for another date to enable us to realize our applications. Benedicta, no objection. Case adjourned to the 7th of October 2021 for hearing of the claimant's applications. Counsel to the first defendant shall inform the second defendant's counsel about the next adjourned date. Then on the 7th of October, Mr. Uchenna said the matter is for hearing of our application, but the first defendant counsel called me on phone and stated that she should not be able to come to court on ground of ill health. In the circumstance, we asked for another date to enable us to move our motion. Then the court said case adjourned to the 26th of November 2021 for virtual hearing of the claimant's application for amendment. I don't think the Mr. Uchenna, did you consider the
Milord, what we did was to withdraw some of the applications. In fact, we withdrew all of the applications.
And when do you withdraw?
Milord, they were withdrawn on the date preceding the last.
On the, was it on the 30th of June?
Milord,
the last date was on the last date was on the 7th of October.
We only informed the court of our intention to withdraw, but we have not withdrawn the application.
Okay, you haven't yet withdrawn.
Yes, not yet withdrawn, my lord.
Okay.
Yes,
my lord.
Yes,
my lord.
Mr.
Yeah, if I'm allowed to comment, just to support what my counsel has said. We actually filed an application on the 29th of June. We complied with the court's order that we should consolidate all pending application. And that application has been filed on the 29th of July, to be precise. It's in the court file, my lord. And the first defendant filed a counter.
To share the application that has consolidated all the pending application for amendment. So I can
Johnson, we did not consolidate the applications. Instead, we decided to jettison the application seeking to join Mrs. Auditor, and the application seeking to substitute the name of the first defendant with that of the partnership law firm, right? So we have decided to jettison those two applications, right? And instead go one single application for amendment.
Okay.
So it's no longer that of consolidation, right?
Okay. Mr. Johnson.
My lord.
Have you heard Mr. Uchenna?
I have heard him in that case.
Say that he has not yet, he has three applications, one for joinder and the other one for, what do you call it? One for joinder and another one for
substitution.
Amendment.
Yeah, substitution. So he intends to withdraw those two applications and proceed with the one for amendment.
My lord, in that case, I should assume that the decision is to run with only one application, and I will have time to, I will have time to respond to the one that he's deciding to go with, since the direction of the court has helped him to clear
that is the one for amendment, and a counter was has been filed.
The counter was filed on behalf of Fidelis Auditor, and my understanding by my counsel was that he was waiting for the consolidated application to respond to it. Because
he was not in court, Johnson, your counsel was not in court on that date. So probably, and I don't think it's the court's place to spoon feed counsel with proceedings in court. He should have made attempts to at least find out what went down in court on that same date. So I really find it very ridiculous that you are not addressed.
But Mr. Uchenna, from the record, I'm not seeing anywhere from the record that you said what I only recorded was that you said you're going to regularize.
Yes, my lord.
that's also on the proceedings of 30th of June 2021. It's in the circumstance we asked for another day to enable us to realize our applications.
Yes, my lord. But on the 7th of October, my lord, I did
yes
of our intention to then withdraw, having filed a fresh application for amendment, to then withdraw the other application seeking to substitute and to join. In fact, you withdraw all the previous applications.
Did you withdraw? You didn't withdraw.
No, I withdrawn those applications, but I informed the court of my intention to withdraw them and proceed with the one filed on the 29th of July.
So Mr. Johnson, in essence, you want to contest the application for amendment?
I would like to contest the application. And if I hadn't been given the impression that
have you read
an application is going to consolidate all issues of amendment, I would have responded to one, at least one that is talking about.
Okay, Mr. Johnson, have you read the application for amendment, claimant's application for amendment?
My lord, I have read it in part. The one that was filed, I think, sometime, the earliest application to amend, the one that was alleging sundry crimes against my person.
No, his application for amendment filed on the 29th of July. Did you?
6th of July?
No, 29th, 29th of July.
My lord, is it possible for a copy of it to be shared so that I can identify that? Is it possible, my lord?
I don't think so.
Okay.
Is dated on
29th of July.
Dated July 21st and filed on 29th of July. It's praying for leave. So the claimant applicant to amend their form of complaint.
Who of July?
So, Mr. Johnson, do you intend to oppose?
I actually would want to respond to any application that suggests or that allows him to place on record in court defamatory and embarrassing material. So if those materials he wanted to place in the record of court,
no, it's an application for amendment, Mr. Johnson.
My lord?
I say it's an application for amendment.
Do you think that
anything against your person in the
proposed amendment? I think I saw one application seeking to amend so as to introduce embarrassing, defamatory, and criminal allegations against my person. If that is the application that is intending to, they are intending to move now, I intend to oppose it, because if what they want to bring in is in the record, I'm entitled to bring an application to ask for it to be struck. So for that reason, I should be able to oppose introduction in the first place. So if that application is what they are talking about now, I would like to propose it. But I hadn't made any opposing application or process before now, because I had the impression that the claimant is bringing a single application that will bring in all issues of amendment in one document, so that it will be responded to in one document and save stress and time of the court.
So you are not ready because you thought that the claimant was going to consolidate
an application that will consolidate all
and
amendment.
You also intend to
yes, I intend to oppose the application.
Claimant's application for amendment. In the circumstance Mr. Uchenna, he's asking for an adjournment to enable him file a counter.
Yes, my
Mr.
lord.
Uchenna.
My lord, I'll be opposing that application vehemently, my lord, for several reasons. My lord, first off, the second defendant is represented by counsel in this matter,
Yes.
and counsel owes that duty to his client to inform him timeously of the proceedings in court and the state of affairs in the matter that he's been engaged to represent his client in. My lord,
Yes.
this is really a failure of counsel to do his duty, and we cannot on that score of his failure to do his duty, not proceed stall on this matter, which on this application that has been filed and pending since July. That means it's been 4 months. 4 months since this application was filed, and I don't see any reason why today, which is 4 months after, counsel is the second defendant is still asking the court for a date to respond to an application that is before the court. My lord, this application is before the court. My lord, it was filed and served on them, and it is the duty of the client of a party to respond.
Sorry, Mr. Uchenna, did the two defendants file any statement of defense? Did they join issue too?
My lord,
Did the defendants file statement of defense?
yes, my lord.
All of them file statement of defense.
Yes, the defendants have joined issues with the claimant.
Okay, they have filed separate statement of defense or
yes.
Joint statement of defense?
Separate statements of defense.
Okay.
My lord, if I may respond to Mr. Uchenna.
No,
Is it
I'm
possible
not sorry. Excuse me. Just a minute. Okay, I'm sorry. So we'll be asking for a cost of 200,000 naira, my lord, against the second defendant.
Mr. 200,000 naira.
200,000, my lord, 200,000. The second defendant is a senior lawyer, my lord, and
that's why you're asking for the cost of 200,000 naira.
Yes, my lord.
My lord, may I respond to Mr. Uchenna?
Okay, yes.
My lord, first, it is correct that I am represented by counsel, and my counsel has an address of service. If I recollect correctly, if the application they are talking about, which they say they want to move now, is the application I saw in my office, they did not serve my counsel. They did not put his address of service in the process, and they did not serve him. The records of the court bind the court on this and the claimant on this. That is number one. Number two, and of course I didn't talk about it because normally if they consolidated or if they brought the final application that according to the direction of my lord, I will have opportunity to respond to all issues. But as they haven't brought it, or as I assume that they haven't brought it, I didn't talk about the fact that they have failed to serve my counsel. Till date, my counsel did not know of the existence of that particular process because they did not serve my counsel. That is number one. Number two, my counsel is also not aware of today's proceedings. I became aware of today's proceedings because I happened to work in the same office with the first defendant, and the notice was sent to the first defendant. A colleague in the office showed it to me, and I had to step in. So basically, that preventing today's proceeding from going on, which is the fault of myself or any other person. So if my lord is minded, the cost should actually be awarded against the party who failed to serve in the process. Assuming this process that he's talking about is the one that consolidates all his application for amendment. If he had served me the process that consolidates all his application for amendment, I would have responded, or at least this indicated whether I am opposing or not opposing. In any event, I don't have to oppose all applications. I just have to have a chance to take a decision whether I'm opposing or not.
Well, sorry, Milord, if I may just respond on one point, the issue of service, Milord. On the face of the motion paper, there's endorsed on it the address for service for the second defendant's counsel, which
At which address?
At 21 Adenu Gatawo Street, off Ikorodu Road, Obanikoro, Lagos.
Was it said?
It was, of course, the applicant has paid for service, has mobilized the sheriffs of the court the bailiffs of the court to effect service.
So whose fault would be that it was not served?
It is not the fault of the claimant or his counsel that the application was not served. It was not served, because of course we will have to rely on the records of the court for that purpose.
But Mr. Ochena, was that application served on the? Because I'm trying to go through the record and see whether the application was served.
You know, we paid for
I need to even be sure of the particular application we are talking about, because there are too many of them. This was why we are talking about all the applications into one.
Who is Stone Books and Stone Books?
Stone Brooks is my counsel.
Eh?
Oladipo Ajayi works from Stone Brooks.
No, your lawyer is from Stone Books
yeah.
and office. Huh?
Yes.
Yes, Mr. Johnson.
My lord?
Yes, who is from Stone Books office?
My lord, I said that my works from Stone Brooks.
Your lawyer is from there?
Stone Brooks.
Is your lawyer from there?
Yeah, he practices from there, even though currently he's not in town.
But because there is an endorsement, signed by one Sitayo on the 3rd of August 2021.
Have the copies.
Is that the application that they are talking about moving? I don't even know the application they are talking about currently.
No, that is the application for amendment.
My lord, there are several applications for amendment. I am talking about which one are they talking about?
Is the one to amend because what the process server did was to attach the front copy of the motion to the hearing notice. You understand, Mr. Jones?
Yes, my lord.
So there is a hearing notice affidavit of service by the process server, and the front copy of the process, that motion was attached to the affidavit, showing, indicating that that process was served on.
My lord, I do not know the whole of details, but I am also bound by the records of the court. But if I must make a mention of a fact, I don't know the particular application that the process server served. If it is the one that has consolidated all the proposed amendments in one document, that is what I'm talking about. I wasn't given any particular application that has consolidated all the proposed amendments in one document as we were meant to believe is coming. If the claimants have changed their mind about bringing a consolidated application for amendment, they could or should have informed all the parties, including the second defendant, so that the second defendant can stop expecting a consolidated application and respond to whichever one they have elected to go with.
What did you say, Mr. Jones? Mr. Johnson, sorry.
My Lord, I was saying that I do not know if the application they are talking about, because currently I don't have a copy here with me. Like I said, I wasn't even prepared for myself. What I'm saying is, if the application that they say they have served is the application that has consolidated all the proposed
No,
amendments.
we're not talking about the issue of consolidation. We're talking about the service of the application for amendment. There isn't any application for consolidation file.
Body that we are not to expect any other application that consolidates all the issues of amendment. They haven't formed the second part, which they made the second defendant to believe in the open court that there is going to be an application that consolidates all issues of amendment.
But Mr. Justice, should we wait for till the claimant files his application for consolidation before you react to the application for amendment? You don't think that there is need for you, once you start with the application for amendment, to just react to it without waiting for the claimant to...
The direction we understood from the court was that all the piecemeal applications for amendment are going to be withdrawn, and one composite application for amendment.
But did the court give any direction?
My Lord,
the court didn't give any direction, Mr. Johnson.
This is based on the report I received. I'm not going to be able to controvert the record of the court, as I wasn't appearing by myself. The report I received was that the claimant has told the court that he bring one application that encompasses all the issues of amendment in one process to enable the parties respond to one particular application for amendment. So as of today, I am still expecting that application for amendment that encompasses all the issues of amendment. I do not know as of today that that application has already been brought, if it has been brought.
Well, would you respect the
Mr. Ochana, why didn't you apply to withdraw? Why didn't you apply to withdraw your other application so that the record would look straight?
My Lord, on the last adjourned date.
No, I mean now. Why wouldn't you now apply to withdraw the other application so that the record will look straight?
As the court pleases, my Lord, we humbly apply to withdraw the application dated the 10th day of March 2020, my Lord. It was dated the 10th day of March and filed on the 11th day of March 2020. So we humbly apply to the court to withdraw the said application, having now been spent. And
we apply to withdraw our applications dated
the 10th day of March 2020.
Dated and filed same date?
No, my Lord. It was filed on the day after, on the 11th of March 2020, my Lord.
Okay, dated the 10th March 2020.
Filed on the 11th.
Filed on the 11th of March. That's the first one, bah?
Yes, my Lord.
Then the second one?
My Lord, the second one is dated the 3rd day of July 2020 and filed on the same date. So we humbly apply to withdraw the said application.
Is dated on file on the 3rd, is dated and filed on the 3rd of July 2020. The first one was for what? Was for gender?
An application to grant leave to the applicant to amend the list of witnesses and witness statement on oath of Engineer Okechukwu Kenneth Nwankwo.
No, the one filed on the 10th of March was for.
Yes. So amendment of list of witnesses, my lord, and witness statement on oath.
Okay, and the second one is for substitution of first defendant's name.
Yes, my lord.
Okay.
No, there's a third application. I want to sort it out from the file so I can do it. There's a third application.
Okay, there's another application.
Yes.
My lord, you can see our confusion.
Just a minute. I want to sort out. My lord.
Yes.
I can't seem to find the third application in the file. I can't for the third application. So that
I cannot also cite it from my file. I'm trying to cite the first application from my file because there are several applications. There is the file is in volumes. I think 2 or 3 volumes. There is an expertise application. There are several counters. There is there is one application filed on. It's here.
okay.
Mr. Ochenda, there is also an application, the one filed on the 11th of March.
Yes,
Is there an order of court granting leave to the applicant claimant applicant to amend the list of witnesses?
We have applied for that to be withdrawn, We have just applied for it to be withdrawn, It is one of the 2 that we have applied on just a few moments.
What about application? I think the one that was attempting to substitute the name of the first defendant with the partnership.
That is the one of 3rd of July, I think.
Is he withdrawing that one as well?
Yes, that's what he said. That's what he said. An order of court for the substitution of the name of the first defendant with that of his partnership law firm to be stated as follows: Fidelis Auditor and Company. Then the law practice partnership name of Fidelis Auditor QC San and Mr. Ochena, the third one you are looking for, you also want to draw that one?
Yes, my lord, I've just seen it. It's an application dated the 9th day of October 2019, my lord. Dated and filed on the 9th day of October 2019.
It's for what?
An application granted to the applicant to amend the general complaint form issued on the 11th of March 2019.
And was not withdrawn at any point in time?
Not me, Lord.
That was this when? The date and file when?
On the 9th day of October 2019, my lord. 9th day of October.
It's also for amendment.
Yes, my lord, for amendment of the general complaint form and other supporting originating processes.
Okay.
Humbly apply for the same to be withdrawn and struck out, my lord.
Hmm?
We humbly apply for the same to be withdrawn and struck out.
So the third application is dated and filed on the 9th of October 2019. That's so?
Yeah. Yes, so that's on me.
Okay. Mr. Johnson, any objection to the withdrawal? Mr. Johnson.
I do not have, as I'm representing two defendants, for myself, I do not have objection. So to withdraw. For Professor Fidelis Auditor, I understand that he has filed responses to three of those applications.
Responses to the
Three applications that has been withdrawn now. He has no objection to their withdrawal. The only question he has is as to the consequences of those withdrawals. So my Lord could as well take it as he has granted the application for withdrawal. The question as to costs that Professor Dita has incurred filing responses to those applications, and the order my Lord should make in respect of those applications that has been responded to and litis contestatio reached is what is outstanding. In my view, or if I may speak for Professor Dita,
respectfully, my Lord.
As those
respectfully to the Honorable Court,
the proper order the Lord should make in respect of those applications is one of dismissal on the authority of Okoronkwo and Young Shagro Motors.
One of what?
Then, on the authority of Okoronkwo and Young Shagro Motors.
That the order to make is one of dismissal?
Yes, in respect of those applications that has been responded to by the first defendant.
Lord,
he has responded to them on the merits.
Mr. Johnson, I don't think that's so, because though as you've said, the first defendant has reacted, has responded to the application.
On
but
the merits.
If there is an application to withdraw, it can be dismissal, I think.
My Lord, I have authority for my proposition.
No, it can't be, because it's not determined on its merit.
Respectful to the Honorable Court, my Lord. Sorry, I'm interjecting, irrespective of that I have a counsel. But my Lord,
no, but
has no right to
represented by
speak for
counsel,
the
you shouldn't,
defendant.
be allow your counsel to so that we'll have
I'm a bit surprised that Johnson is doing his case as a party in the suit, and it's also speaking as a counsel for the first defendant, my Lord.
Represented by the counsel, but since you're represented by a counsel, today, you should allow your counsel to say whatever you want to say on your behalf. The reason why I'm giving Mr. Johnson a hearing is that this counsel is not in court, and whether it's a lawyer or not. As a matter of fair hearing, a second defendant, since his counsel is not in court, as a matter of fair hearing, he should be heard. And for you, since you have been represented by Mr. Uchenna, I think you should allow Mr. Uchenna to conduct the proceedings, so that we'll have
as a court pleases.
As a court pleases. But my Lord, he can't speak for the first defendant. He has no right to do that, my Lord. With all due respect to the Honorable Court, he's speaking for the first defendant.
My Lord, I announced my appearance for myself and the first defendant, and I'm a lawyer, and there is no law that says a defendant cannot.
But you have a lawyer representing you, Mr. Johnson. You have a lawyer representing you.
Yes, I have a lawyer representing you, but
you are not representing. You are not representing the first defendant.
On today's occasion, I announced my appearance for the first defendant and for myself.
As a lawyer, or as just a representative of the defendant?
As a lawyer for the first defendant and as a party in person for myself.
But can you appear as a lawyer after you have been given service of?
Yes, my Lord. And
you can appear as a lawyer after you. Then what's the essence of engaging service of your lawyers?
My Lord, the law is actually very clear on this.
No, you cannot appear as you can only appear as a party. You can only appear as a party.
My Lord, may I
you're already in the service of a lawyer. You can't make a case for the first defendant. The first defendant has his lawyer.
That's actually not the law, my Lord. The law currently, I could even sit at the bar and wear my wig and gown representing both myself and other clients.
Okay, should I record you that you are disengaging the lawyer that you have engaged?
I haven't said so, my Lord. I'm only appearing for myself.
So since your lawyer has filed his memo and whatever, you can't just come to court and say that you are now representing yourself and the first defendant as a lawyer. After the first defendant has engaged service of a lawyer. No, we have to have decorum in the appearances and
As the court places, but I need to make this legal point. My Lord, I need to make this legal point. There is actually no law says that I have to disengage my counsel before I can appear in court for myself or for any person. As of today, since my lawyer is not
okay,
in court,
so we can say that today you can appear as a lawyer for yourself, for the first defendant. Then on next agenda, the lawyers for the
when the
first
parties
defendant,
because I have authority
also
of the first defendant to appear for him today. I have authority of the first defendant. I became aware of today's proceedings.
If you have his authority to go on with the case, the first defendant has filed a counter to the motion for amendment. It means you can go on with the motion for amendment.
With the first defendant's own case. That is what I just explained.
Yes, he has filed a counter to the first defendant has filed a counter to the motion for amendment, and you say you are presenting. So since you are presenting, it means you are going to go with the case of the first defendant as part of the motion for amendment.
My Lord, as it relates to the first defendant, I could go on, but as it relates with myself, being that I haven't received I haven't actually acted for myself in respect of those applications, I cannot go on. But for the first defendant who has responded to 3 applications that have been withdrawn today, I am pleading his case that he's entitled to his cost and the proper that the court should make in those circumstances.
But you shouldn't forget, Mr. Johnson, you shouldn't forget your statement saying that you can't speak for the first defendant about the issue of withdrawal. That's what we are saying. And you're not saying that you are not.
No, what? Maybe I'm not understood correctly. Let me explain myself, if my Lord permits.
If I may come in,
if my Lord permits, may I explain a little on that subject?
I think Mr. Agu has had his time. If I may come in.
You do not decide that. I'm still addressing my Lord. My Lord decides has had his time or not.
And you even said that you didn't know about the case.
My Lord, I explained that I do not know the details of the case, which is correct. The one I'm talking about now is the 3 applications that have been withdrawn now. I know for a fact that before today, the first defendant has responded to those applications. And I'm speaking with regards to his legal right as to costs of responding to those applications and the appropriate order my Lord should make in the circumstances.
My Lord, if I may respond to the issue of cost that Mr. Agu has raised briefly. My Lord, there are 2 issues here, my Lord. One is that, and they are very fundamental issues, very, very fundamental issues. One is Mr. Agu's competence to represent himself and appear in person, and at the same time represent another party in the same suit. My Lord, that is I don't know where that practice was imported from, but it's certainly not part of our jurisprudence here in Nigeria, my Lord. A party cannot represent himself and at the same.
So this is my ruling. Claimant's application. Claimant's 3 applications. One, they said the 10th of March 2020, but filed on the 11th of March 2020. The second one, they said on file on the 3rd of July 2020. And the third one, they said on file on the 9th of October 2019. Having been withdrawn, is hereby struck out.
As a couple places.
As a couple places.
Yes.
Yes, Lord. My Lord, I was saying that Mr. Agu cannot, in the same breath.
No, we are not going to adjourn the matter for hearing of the trainable him file his counter so that we save time, please. So that we
As a
save
copy,
time.
as a copy.
Yes.
As the call pleases.
Yes, 18th of January for the hearing of the motion for amendment.
My lord, when?
As a copy.
18th of January.
18th of January. My lord, is convenient.
Because we're going for Christmas this break.
Yes, my lord.
That's
So
vacation.
Is it okay?
My lord, as a copy, I'm comfortable with that. I will only have to communicate my counsel and the first defendant's counsel.
Okay, now. Then the next time is your counsel is going to come to court. But today, Mr. Uchenna, is it okay? Mr. Uchenna. Yes, Mr. Uchenna. Mr.
My lord, it's
Uchenna.
possible he's experiencing some network issue.
My lord? My lord?
Is the date okay? Yes.
Yeah, I think it's better now.
18th of January 2022 for hearing of the motion for amendment.
My lord, it's convenient.
Okay, thank you.
It's convenient.
So, Mr. Johnson, it means we don't even need to issue any hearing notice to the first defense because you're presenting them.
My lord, yes, I will communicate them.
No,
That's
since you're
what I'm
we don't even
explaining, my
need
lord.
to. Okay.
That as of today, I am representing both myself and the first defendant, so there is no requirement of hearing notice. That's what I'm explaining, my lord.
Okay. So case is adjourned to the 18th of January 2022 for hearing of the claimant's application for amendment. The second defendant shall communicate the date to the first defendant.
As
As
a
a
call
copy.
pleases.
So
As a
gentlemen,
copy.
that's all for today. I wish you a very good evening.
Most grateful, my lord.
Thank you, my lord.
Thank you and bye.
Most grateful
Thank
to those
you.
honorable courts.
Okay, bye-bye.